So I hope you all had a good lunch, and we're ready to start on our next panel. This is a panel on jurisdiction and choice of law, and it's going to be moderated by Troy McKenzie. And Troy is also a member of our faculty co-director of the Center on Civil Justice. He took a leave of absence to go to Washington, D.C. for a couple of years, but he's now back with us, and we're very thankful for that. I think you all know that Troy is a brilliant expert in civil procedure and complex litigation, and specializes in bankruptcy. And Troy, I'll turn it over to you.
Well, thank you very much for that introduction. Not just an expert, but a brilliant expert, which I mean, who?
Say brilliant in my notes.
Oh, excellent. Okay.
That was the improvisation.
Improvisation. The jazz. There we go. That is what I want. I do. Everyone, this is a panel that is somewhat different from this morning's panels in that we are going to be talking about a particular topic, a procedure-heavy topic, in a way that might at first seem narrow and doctrinal, but will open up a broader discussion about the dynamics of aggregate litigation in light of changes in the law driven by Supreme Court decisions. So our title is Jurisdiction and Choice of Law. These are not narrow topics, but we are going to try to focus them during this discussion. I'm going to start out by just giving a little bit of a minor overview of where we are and why we're here. As you probably know, between 1990 and for the next 20 years, the Supreme Court paid essentially no interest at all to personal jurisdiction. It was not a topic the court seemed to have any interest in deciding. Conflicts, choice of law issues, similarly not much activity at the court. And then, starting in 2010, the court has taken a number of cases in this area, and in particular, the court has decided several cases in the personal jurisdiction area that, for those of us who teach in this area, are significant and perhaps increasingly significant. Both decisions involving general personal jurisdiction and what specific jurisdiction means. And at least a couple of these cases have involved the type of structure of litigation that is most of interest to us today. So I'm going to begin by turning to Robin Effron, who will talk about development in the law of specific and general personal jurisdiction over the last few years, up to the Bristol-Myers Squibb case.
Okay, so thank you very much. So my assignment is to talk about the background and the developments in the law, but I figured that this is a room full of people who are pretty up to date on at least the basics of personal jurisdiction. And I'm also told that someone has been assigned to respond to me. So I feel like I should say something mildly provocative so that there's actually something to respond to.
Abolish personal jurisdiction.
Abolish personal jurisdiction and ICE at the same time. All right. So now we've covered everything. Okay, so before 2011, the world of general jurisdiction seemed fairly clear, if fuzzy, around the edges. The understanding was that there was general doing business jurisdiction, such that, assuming one had the proper long-arm statute coming from a state, that if an entity was doing enough business, right, systematic and continuous business in a state that they would be subject to general jurisdiction there. Specific jurisdiction, right, had splintered into all manner of avenues depending on what kind of claim was at stake, what kind of case. It's sort of the biggest open question before 2011 was the stream of commerce question from Asahi, right? What level of purposefulness or foreseeability or directed activity was necessary toward a statement? And that's a case that is especially meaningful here since so much of what we're talking about involves product or products liability. And so things changed in 2011. And I'll talk a little bit about sort of the new general jurisdiction and then specific jurisdiction. So first in Goodyear, which was in 2011, and then a few years later in the Daimler case, the Supreme Court really narrowed general jurisdiction. So the idea of general doing business jurisdiction as a constitutional basis for personal jurisdiction was gone, and now we have the essentially at home test. And what the court gave us was a test in which they said, you really have to be essentially at home, and that doesn't just mean doing a lot of stuff or selling a lot of stuff in a state. We're looking for something that is more or less corporate headquarters or the state of incorporation, right? Something that was going to map roughly onto the Hertz case from subject matter jurisdiction, although they were careful to tell us that these were not going to be synonymous. And so this narrowing had a number of effects. One, and I think that Justice Ginsburg's maybe intended effect, although certainly not the outcome, was to put more pressure on specific jurisdiction, right? The idea being that general jurisdiction was too broad and too all-encompassing, and that it was better to sort of tie jurisdiction in most cases to the actual case or the claim and not just have these large swaths of the country where people or entities could be subject to general jurisdiction. Of course, that didn't really happen. Another thing that sort of comes out of narrow general jurisdiction that I want to put a pin in for purposes here is that every time we narrow the availability of states as being a place where maybe any type of claim can be brought, it becomes harder and harder to find a single forum where a plaintiff might sue multiple defendants. So I think some of that will come up a little bit later in some of our other panelists talking, but I'll just sort of put like a post-it note on that now, that narrower general jurisdiction is going to start to become problematic when you're adding certainly lots of defendants to cases and also possibly many plaintiffs or claimants as well. And then another thing that happened is that in the wake of general jurisdiction being narrowed, there's been a real resurgence in interest on registration statutes. So registration statutes go all the way back, right, to sort of the beginning of time. And if you teach civil procedure, time obviously begins with Pennoyer versus Knapp, right? So these registration statutes are state statutes that say if a foreign corporation, meaning a corporation or an entity not organized under the law of that state, registers to do business in the state, and by the way, we might really make you register to do business here, or all sorts of other consequences may follow, that you appoint the Secretary of State or some other official as your agent for service of process. And some of these registration statutes are general jurisdiction in nature, and some of them are specific in nature. And so for a very long time, as long as general doing business jurisdiction was available to sort of capture the activities of larger defendants, and specific jurisdiction would sort of capture a lot of other things that were going on where there was a more obvious connection with the forum, these registration statutes maybe weren't so important, right? Maybe they were used from time to time, people thought about them, they were a footnote in a casebook, but it wasn't something that people were focused on. Now this has become an opportunity for thinking about, could this be an adequate substitute for general jurisdiction, right? Could we sort of have a backdoor into general jurisdiction over entities by looking at registration, right? And saying, oh, actually you've consented to be sued here, and to be sued here for anything, right? Whether it is related to your activities within the forum state or not. And with what little time I have, I'll just sort of throw out there the many problems that people have suggested with registration statutes. If there's a question about whether this form of consent should also have to come along with minimum contacts or not, right? That's an open question. And there are some other questions too. For example, we run into issues elsewhere in the Constitution, unconstitutional conditions, and whether this is sort of a restriction on interstate commerce. So one thing I also want to kind of point out is that this idea of consent, which people might be worried about, we could set alongside some of the recent jurisprudence in forum selection clauses, right, which the court has been very enthusiastic about, right? The idea of looking at consent to a forum as trumping a lot of other considerations. Now, in the Atlantic Marine case, right, that is a forum selection clause. It's a contract entered into by two private parties. I imagine that many people and the court would think differently about consent when it is a matter of implied consent and the parties are the state and a private party instead of two private parties. But again, that's just something to think about. So specific jurisdiction didn't so much change as it did take a turn and just become increasingly unclear, right, with the Jay McIntyre case. There was no majority in that case. I remember that even before it came down, people were very excited. They were already scheduling symposia, and when
Who are these excited people?
this group of people, right?
Thank you.
Right?
Yes.
Thank you. I think that was around the same time that some of like the ACA litigation was going on, and all of my normal friends were excited about like healthcare, and I was really excited about personal jurisdiction. And when the case came down, I remember I asked Adam, I was like, what are you even going to write about? And I believe Adam's answer was, WTF Jay McIntyre. I still believe you should have written an article with that title.
That one's forthcoming.
That one is forthcoming. So Jay McIntyre, right, there's no majority opinion. The court can't agree on a rationale. And the thing that I want to sort of, there's so much to be said about specific jurisdiction, and I theoretically only have 3 minutes left here. So what I want to point out, instead of kind of taking everyone through the slog of, this test and that test, is that what we have seen with Jay McIntyre, and then some of the cases that came after it, like Walden, Bristol Myers Squibb, which we'll hear about in a minute, is an increasingly formalist turn by the court. So even if I think it's somewhat unclear exactly what the tests should be or how they should be applied, I think it is the case that more members of the court than not are interested in very formal understandings of specific jurisdiction as being tied to territoriality and sovereignty, and again, returning to the beginning of time with Pennoyer. And what this leaves out are other considerations that used to have more prominence, even if people couldn't agree on what they meant. So for example, the extent to which litigation is burdensome on the defendant. And by burdensome, I mean actually burdensome and not just psychologically burdensome, which is what it's become now. Whether it is something in which the plaintiff's interest should play some role, what the forum's interest is in that case, right? All of these have taken a backseat to this formality, or I'm sorry, this formalism. And I think the reason that's particularly significant when we're sitting in a room talking about MDLs is that MDLs, I think a lot of the panels this morning were really focused on this. MDLs are anti-formalist, right? You heard that whole discussion this morning where there's a lot of tension between people who say, why don't we have more rules for MDLs? The rules we have, we don't know what they say. And then other people, right, and I think sort of the dominant narrative from some people this morning saying, we don't want or need more rules for MDLs. The hallmark of MDLs is judicial management and each case being different, each MDL being different, taking things as they come. And so, you know, I guess I could say more about this in Q&A, but for now, I just want to tee up what I see as a little bit of a collision course between the real return to formalism in personal jurisdiction doctrine versus the much more functional approach that we've seen in MDLs, and whether the push for more rules and more written rules in MDL is actually part of sort of a larger turn in the law that we can see reflected in jurisdiction too.
So Robin, a very quick question for you before I turn to Linda. It seems to me that when looking at the specific, and actually the general jurisdiction cases up to Bristol-Myers, it's not clear to me that the court is thinking about any of what we've been talking about. The court is not thinking about the treatment of complex litigation within the United States. McIntyre, overseas defendant, U.S. plaintiff. Goodyear, overseas defendant, U.S. plaintiff, overseas conduct accident. Daimler, foreign plaintiff and foreign defendant, foreign conduct. That the court, the turn towards that kind of territorial formality, I think I know why the court is moving in that direction, because they're not thinking about these types of cases, but of course the law that the court develops in these cross-border extraterritorial type cases is law that will end up having an effect on the ground in purely domestic cases as well.
Yeah, I mean, and somebody, a few people have read, one person actually wrote an article with the title outlier cases. I think that that's very true, right? These sort of outlier fact patterns, and certainly fact patterns with foreign defendants and foreign conduct have driven a lot of the analysis. Or when they haven't, they're sort of weird fact patterns, like the BNSF case, which was about FILA. That's just not a statute that is invoked very often in the regular run of cases, right? Unless you're an employee of a railroad. So it's true that these sort of outlier cases have driven the discourse. I don't think they're thinking about that. I think the other problem is they think that they know what they're not thinking about, and that might not be the right answer, and that's the internet, right? So you can see that in some of the opinions. They're like, I don't want to say too much because this isn't about the internet. And I think there's this focus, this idea that they're going to say something, it's going to affect cloud jurisdiction, that's going to mess everything up, when in reality they're missing like a really big piece of litigation that is actually before them, which are real things happening to real people, right? I would also, sorry to take up more time, just point out that in some ways these are outlier cases and in some ways they're not. So Jay McIntyre, right, they set it up like there's this foreign manufacturer and they have this strange way of doing business where they sell things to a distributor who sells them in the United States, as if that isn't how almost all products get into the United States and are sold here. You know, I teach international business transactions as well as civil procedure, and I remember reading that case and I'm like, do you understand trade? Like, this is not some weird, this is not some bizarre business arrangement that we're trapping just Jay McIntyre in, right? This is how products get here. And so I think there is a lack of understanding, not just about aggregated litigation, but just about the relationship of people, products, defendants, and other claimants.
So now I'm going to turn to Linda Silberman, who will take us from Bristol-Myers Squibb forward.
Thanks, Troy. I just want to say I think you were quite right to say that the court isn't thinking about nationwide class actions and when they did any of these cases, because in the era of general jurisdiction, the jurisdictional issue was not really a big problem. And as you move to specific jurisdiction, it isn't a very good fit for class actions. And that's why we are left with all of these questions after the Bristol-Myers case. In the Bristol-Myers case, and let me just give a quick factual review of it. The plaintiffs from various states had purchased drugs from a Delaware corporation headquartered in New York with its principal place of operations in New York and New Jersey, but it had extensive business activities in California. California residents who purchased their drugs in California and suffered their injuries in California, and then residents of other states who purchased their drugs outside of California and were injured outside of California brought their product liability suit in California state court. The California Supreme Court upheld jurisdiction over Bristol-Myers with respect to all of these plaintiffs' claims, characterizing even the claims brought by non-California purchasers as giving rise to specific jurisdiction. At the time, it probably didn't seem very strange at all because there would have been general jurisdiction in California, but general jurisdiction is now gone, as Robin explained. So the California majority describes the claims by both the California and non-California plaintiffs as based on a single coordinated nationwide course of conduct, and they said even these claims of the non-Californians arise out of or relate to the California activities, and they say this is a kind of sliding scale of general jurisdiction, and they conclude that all of these claims have a substantial connection to California and either relate to or arise out of the activities of BMS. The dissent disagreed, stating that these are really parallel claims and that the majority had undermined this relatedness requirement that we've always had with and is the essential distinction between general and specific jurisdiction. The Supreme Court grants certiorari, reverses in an 8-1 opinion by Justice Alito, who rejects any sliding scale, criticizes the California Supreme Court for blurring these quite distinct lines between the kinds of things that are necessary for specific jurisdiction, and in confirming that there is a strict line between general and specific jurisdiction, they say what you need is an adequate link that must exist between the specific claims that are being asserted and the forum. Now, Justice Sotomayor dissented, and on the issue of relatedness, she says the fact that the injury arose outside of California doesn't mean that these claims didn't relate to the sort of advertising and the distribution efforts that Bristol-Myers had undertaken in California, and she was particularly concerned about the piecemeal litigation that's created by the fact that multiple plaintiffs may not be able to join their claims in a single action. Now, of course, plaintiffs with multiple claims can join together in a forum where the defendant is at home, and therefore, plaintiffs could have brought their claims in Delaware or New York. Prior to Daimler, they could have brought them in California and probably in many states in the United States. And in fact, the Bristol-Myers plaintiffs had actually engaged in a deliberate forum shopping strategy by structuring the lawsuit first to keep the case in California state court by joining a local defendant and limiting the number of plaintiffs to fewer than 100 to avoid a mass action getting removed under CAFA. So they tried very hard to keep this case in state court. I just should point out that if they got into federal court, it wouldn't have made any difference in terms of the jurisdictional reach. Now, there's Justice Sotomayor's famous footnote 4 in her dissent, in which she raises this issue of nationwide class actions. And she asks whether a plaintiff in a forum state would be able to represent a nationwide class of plaintiffs who are injured elsewhere. The majority, I think it's fair to say, doesn't really address the point, although Justice Alito said Bristol-Myers concerned the due process limits of the exercise of specific jurisdiction by a state. And at least he says, leaves open the question of whether the Fifth Amendment opposes the same requirement of the exercise of such jurisdiction by a federal court. Now, I find that statement puzzling because although the Fifth Amendment has been interpreted to permit contacts with the United States as a whole, the reach of the federal courts has traditionally depended on a federal statute or a federal rule in the first instance. And maybe at the end of the day, that is one of the solutions. I'm not sure it's just sort of the Fifth Amendment operating on its own. Now, there are a variety of different scenarios that have confronted courts looking at what the impact of Bristol-Myers is on federal class actions. And they've come up with a variety of different rationales for their conclusions. So let me start first with named class members. So the question is whether each named class member must have specific jurisdiction over the defendant. Remember, Bristol-Myers is a joinder case, not a class action. But the district courts have found that the situation for named plaintiffs is much the same as Bristol-Myers. They say it's very much the same, and each named plaintiff has to satisfy the constitutional requirements to assert jurisdiction over the defendant. The one exception is maybe a second case now, which involved resident and non-resident plaintiffs asserting a federal claim and various state law consumer claims on behalf of a nationwide class. And although Sloan, I think, is an outlier case, it does offer some additional theories to justify jurisdiction on behalf of the named plaintiffs, and they're at least worth thinking about in thinking about ways that one might avoid the impact of Bristol-Myers. They first suggest, because this case involves a federal question case in federal court, although I point out, not a case where there was nationwide process. Court says the due process analysis does not incorporate what they characterize as the interstate sovereignty concerns that animated Bristol-Myers. And they point to language in Bristol-Myers that focused on the fact that a defendant was having to submit to the coercive power of a state that may have little legitimate interest in the claims in question. So it was a notion that the state court was exercising jurisdiction. And in the present case, because the case was a federal court, it thought that this risk of exceeding the bounds of state sovereignty was not at stake. Second, although the court acknowledged that there was no independent connection between the out-of-state plaintiff's claims and the defendant's California context, it believed that they could use the concept of pendent personal jurisdiction, and they could extend it to reach named plaintiffs who had state claims. So the named plaintiffs had federal claims, but these other plaintiffs these other named plaintiffs had state claims, and they thought that they could use this doctrine to have a pendant process concept. And finally, as a matter of policy, the court said that we ought to avoid piecemeal litigation. So they thought that this federal question case, even without nationwide jurisdiction, would work. There's a later MDL case that deals with this issue in the transfer court, and there the plaintiffs had a nationwide process, and then they joined other out-of-state plaintiffs to that claim. So let me then turn to the question of unnamed plaintiffs, that is absent class members, where I think the results in the lower courts are mixed. A number of courts have held that the requirement of independent personal jurisdiction over the defendant doesn't reach absent class members, and why is that? It's because in other contexts, non-named class members are not considered parties. And there are a number of cases, including the issue of subject matter jurisdiction and diversity. So they don't count. So if unnamed class members are not considered parties, then jurisdiction over the defendant is only required with respect to the named representatives. But the question left open, maybe to be decided at a later stage, is whether the named class plaintiffs will then be able to meet all of the Rule 23 requirements of adequate representation, typicality, predominance, and superiority in order to certify a class of out-of-state absent class members where applicable law issues, among other things, might create obstacles. And explaining why absent class members in a putative class action should be treated differently than named plaintiffs in a mass tort, which was Bristol-Myers, one court noted that a case only qualifies for class action treatment after it meets the Rule 23 requirements of numerosity, commonality, typicality, adequacy of representation, predominance, and superiority. And they say, look at that. You have to satisfy those elements, and they provide the due process safeguards that we did not have in the mass tort context of Bristol-Myers. And also, as another court pointed out, the economies achieved by aggregating claims under Rule 23 are completely compromised if a court in a class action has to ascertain whether specific jurisdiction can be asserted over each absent class member's claim. Now, a number of courts have taken the position that what they should do is they should wait until a class is certified to even reach the personal jurisdiction case. And in one such case, there were New Jersey and Pennsylvania residents who had brought a nationwide class action against a California corporation in New Jersey, alleging claims under, I think, New Jersey, Pennsylvania, and California state consumer fraud statutes. The court dismisses the named plaintiffs, but retained the claims of the named New Jersey plaintiff and then the rest of the class members. And with respect to the non-named class members, the court said, because the class members are not yet parties to this case, and they may not be, absent class certification, I'm not going to look at specific jurisdiction. At the same time, they noted that the ability of the named New Jersey plaintiff to represent non-New Jersey class members was likely to depend on the choice of law determination. So if they used California, which was the home state of the defendant, then they could represent everyone. But if New Jersey law was going to apply, they could not. I just should say other courts have taken a different view. They have said that this case is very much like Bristol-Myers, and that the certain kinds of forum shopping concerns that were expressed in Bristol-Myers applied equally here. The last point, and I have just a couple of minutes, I see, was this issue of the Fifth Amendment. And the courts, a number of courts that thought this was not different, said, look, in cases certainly where it's based on diversity, it's the 14th Amendment that it is important. To close, let me just say that with respect to the MDL actions, it seems to me that the MDL may, as a result of all of this, be quite attractive, and that is because the jurisdiction will be determined in the transfer or court. And so if you have sort of separate actions in the individual court and they are then transferred, you may be able to have single specific jurisdiction cases then moved to the MDL. And I think Teddy and Andrew will address that.
Thank you, Linda. So one thought about that, though, is that class actions and MDLs are sometimes, the MDL might be the holding place, and then the product is maybe a class action. You can certify a nationwide class action and resolve the litigation that way. And you still might have these BMS concerns that might either cut off or limit that as the end procedure or mechanism for tying up the litigation. If a court, and I know there are several Northern District of Illinois cases that take the view that you have to, BMS applies with respect to the absent class members. If that's the case, and if you're trying to certify a nationwide class in order to resolve a major litigation that has been consolidated through an MDL, then maybe you can't. Maybe you have to take some other approach and some type of aggregate settlement, a quasi-class action, or something else.
Maybe, and the other thing just to point out is when you think about CAFA, for example, it's enacted before Daimler. And when you look back and you see there's no nationwide jurisdiction in CAFA, why not? Because they probably didn't think they needed it. And maybe now they do.
Yeah. So at this point, we're going to turn to the heartland questions of how all of this affects the MDL process and strategic considerations by lawyers in MDL litigation. And I'm going to turn it over to Andrew Bratt and Teddy Rave, who are going to flip coins for the discussion, or are going to go back and forth. I'm not sure. want to say?
Andrew can go first.
Oh,
I'll start and I'll pass the time.
that's very generous of you, yeah.
Of me?
No, I mean of Teddy.
That's the way it usually is. All right, well, thank you, Troy. I'm going to talk about personal jurisdiction and multi-district litigation together. And some of the challenges that this new case law in personal jurisdiction poses for MDL, because you have this odd juxtaposition of MDL growing and growing and becoming more and more important at the same time that personal jurisdiction becomes more and more restrictive. Ultimately, MDL continues to and has skirted serious questions about personal jurisdiction, and I think it will continue to. It's my view that MDL is constitutional as a matter of the Fifth Amendment, even post-Goodyear and Bristol-Myers. And in fact, Teddy and I think that Bristol-Myers is going to be a boon to MDL. And when I turn it over to him, he's going to explain more about why. Before saying something specific about personal jurisdiction, though, I thought since we were commemorating 50 years of
Saying something specific about personal jurisdiction, or
Well,
something
or
general,
just,
or
you
general?
know, general, specific.
Okay.
I don't want to be territorial. Since we're commemorating 50 years of multi-district litigation, I thought it would be a good moment to say something about the folks who drafted the statute, primarily Phil Neal, the Dean of the University of Chicago Law School, Alfred Murrah, federal judge in Oklahoma City, and William Becker, a federal judge in Kansas City. And they came up with this idea a little more than 50 years ago, and their primary goal was to centralize the power of the federal courts to meet what they feared would be a litigation explosion. And in particular, a litigation explosion in mass torts and products cases that would be in a world where they were distributed nationwide, would lead to nationwide litigations. And the fear was that those litigations would overwhelm the federal courts. And so the decentralized model of federal courts would be inadequate in order to deal with this coming explosion. And so the drafters' conclusion was that we needed to centralize power, at least over pretrial proceedings, in the hands of a single judge. They did not think that their statutory product was going to be a nothing burger, although it did sort of quickly get overshadowed by Rule 23 and the amendments to Rule 23 in 1966. But they always believed that the MDL would be the primary vehicle for aggregating mass torts. And so I think I'd like to think that somewhere they're feeling sort of vindicated and happy with themselves about this event. But nevertheless, one of the reasons why they felt there needed to be an MDL statute was that there needed to be a way to consolidate cases before a single district judge. And the transfer statute was inadequate because of its requirement that cases could only be transferred to districts in which they might have been brought. And so there needed to be some mechanism that allowed cases to be transferred to any district if they were all going to be consolidated in one place. But it's worth noting that in the 1960s, when they were drafting the statute, their primary concern was not limitations on personal jurisdiction, but limitations on venue, because that was the heyday of doing business jurisdiction, and they typically believed that there would be personal jurisdiction nationwide, over a nationwide set of claims over most defendants in states where they had continuous and systematic operations. Obviously, as Robin noted, since 2011 in the Goodyear case, this has changed a lot. In any event, in the 1960s, when they were drafting the statute, their original idea was something that they called a radical forum non conveniens statute. That is, something that would transfer all cases for all purposes into one court. But they backed away from that because they thought it went too far, both as a doctrinal matter and as a political matter. That is, the plaintiff's bar was deeply opposed to that because they were worried that they would lose their cases. And federal judges were not so excited about that because they worried about having to try thousands of cases all at once. So they come up with the idea of limited transfer for pretrial proceedings. And this limited transfer for pretrial proceedings, followed by remand to the court where the case was originally filed, turned out to be a genius idea. Not only was it politically saleable, it gave MDL what Teddy and I think of as some of the mainspring of its power, which is this split personality. That it allows MDL to look simultaneously like a collection of individual cases that fit with our traditional norms of jurisdiction and choice of law and litigant autonomy, but really put everybody together into a very tight collective. And this was not lost on the drafters of the MDL statute. In fact, it was considered really important to them that there be no opportunity to opt out of an MDL. Because if you could opt out of an MDL, then it would wreck the whole MDL. It would defeat the purpose. You have to keep everybody stuck in the aggregation in order for the system to work. Now, just because MDL has this split personality, this patina of individualism that masks a tight collective, doesn't mean the problems of personal jurisdiction and choice of law go away. They're in fact there in all of these cases. It was particularly true for plaintiffs and defendants in MDL. If you're a plaintiff in one of these cases, your case might get transferred far away to a forum where there might not be jurisdiction over you otherwise. And if you're a defendant, you might wind up facing a nationwide set of claims in a forum that wouldn't have general jurisdiction over you, at least under the Supreme Court's current case law. So if all of those problems still exist in the MDL, then why is it that MDL seems to have skirted any real scrutiny when it comes to personal jurisdiction? And it has skirted any of that scrutiny. It's clear that the Judicial Panel on Multi-District Litigation doesn't really care about personal jurisdiction. They believe they could transfer a case anywhere. And in lots of nationwide products liability cases, they will say there's no one district that's the focal point for this litigation. So we're going to pick some place that in some cases is either in the middle of the country because it's geographically central, or one of the coasts of the country because it's easily accessible, or in a place where there's a judge that they want to give an MDL to who's never had one before, or a place where there's a judge who's had lots of MDLs and has done a really great job with them, and therefore he or she should get it. So this is not a concern for the panel. As Elizabeth Cabraser has said before, I think quite eloquently, it's not a where problem, it's a who problem. They don't care that much about geography, they care about the individual district judge. Now, even though, as a practical matter, personal jurisdiction isn't really an issue in MDL, there's certainly doctrinal problems here. And the doctrinal problems, I think, are highlighted by the fact that there are two separate contradictory explanations for why you can put a nationwide MDL in one court, given by the JPML on one hand and the few courts to address the matter on the other hand. The JPML, in a set of decisions that I go into in an article called The Long Arm of Multi-District Litigation that I think is included in these materials if you're really looking for something to do. They say, effectively, that all that matters is that there is jurisdiction in the transferor court. It doesn't matter if there's jurisdiction in the transferee court. And the thought is, well, as long as there's jurisdiction in the transferor court, the place where the case is ultimately going to be tried is the one that matters. And then the plaintiffs don't, or the defendant doesn't lose anything, because the defendant wants to object to personal jurisdiction in the transferee court. They can do so on the basis of the jurisdiction in the transferor court. Now, of course, this is all assuming a world where nothing of importance really happens in the transferee court. But the reality of MDL, we know, is that everything important happens in the transferee court, including the possibility to grant a dispositive motion. And so this idea that, well, all we have to worry about is whether the transferor court has jurisdiction seems to me to be a little bit of missing the point. Now, the few courts that have addressed the question of whether there's jurisdiction in the MDL court say something different. They say, no, the MDL statute is a nationwide service of process statute. Except that it's not. It doesn't provide for nationwide service of process. Otherwise, you could directly file any case in an MDL court without a stipulation by the defendant. And also, it would probably mean that lexicon was incorrectly decided. Yeah. And it would mean that it was probably the most aggressive use of nationwide service of process that Congress has ever attempted, because there's no possibility of transfer, there's no narrowing venue statute, there's no real right to appeal, and the scope applies to all potential state law actions in diversity so long as they share a common issue of fact. So not only is it not a nationwide service of process statute, if it were one, it's one that surely tests the limits of what the Congress could do. Now, MDL, of course, as I said, has managed to skirt this and lots of other problems when it comes to these jurisdictional questions. Courts and parties just haven't been worried about it. And that brings us to BMS. Now, one of the reasons why BMS is such an odd case is that in BMS, the defendant wanted very badly to get out of San Francisco Superior Court. They fought tooth and nail to get out of San Francisco Superior Court. But throughout the whole litigation, They said, well, an MDL right around the corner in the Northern District of California would be just fine. And they said, well, what does that mean? Isn't personal jurisdiction supposed to be about geography or distant forum abuse? And what the defendant says is, no, we consider the California state courts the lowest common denominator, and we want to get out of there. Now, as a Californian, I took this slightly personally, but nevertheless, that seems to be what's going on here. These are arguments that we think about mostly in terms of diversity jurisdiction that are being deployed in personal jurisdiction. Now, I am not going to argue here, despite everything that I've just said, that the MDL statute is unconstitutional. That would be a rough end to this event, or at least a rough middle part to this event. And if I were to come to that conclusion, it would be silly. The whole point of MDL is to be able to aggregate these cases in a single place. To some degree, the MDL statute has just become too big to fail in that way. So instead, I think what we need to do is look at jurisdiction in MDL in a different way. That is to say, when we look at jurisdiction, it's not about only the jurisdiction of the transferor court, although that's important for reasons that Teddy will discuss, but also what is the jurisdiction in the transferee court? And that jurisdiction is not based on territorial principles, it's based on the national interest in efficiently resolving mass torts. And if you look at it that way, and weigh it in a reasonableness analysis against the interests of the individual parties of litigation, I think that in most cases, MDL will pass constitutional muster. But it's not for the fictional reasons that the panel and the court have said so far. So the result is that I ultimately think, whether you're looking at it under the fictional way that we do now, or what I think is a more nuanced way, personal jurisdiction in MDL survives Bristol-Myers Squibb. And in fact, I think, as Teddy will say, Bristol-Myers Squibb will be quite a boon for multi-district litigation.
Well, thank you, Andrew. And now, Teddy, say what you are supposed to say.
So I've been instructed in what I'm supposed to say. I'm going to talk a little bit about the effects of all of these personal jurisdiction developments on MDL. As Robin and Linda told us, these recent developments in personal jurisdiction doctrine, particularly Goodyear and its progeny and the Bristol-Myers decision, limit plaintiffs' options for where they can aggregate claims. So no longer can plaintiffs shop around for the friendliest state court that they can find to bring a nationwide class action or nationwide mass joint. Plaintiffs can, of course, still sue individually or in small groups in the states where they suffered injury or perhaps the states where they live. But if they do that, then they have to give up all the advantages that come with aggregation. If plaintiffs want to aggregate their claims on a nationwide scale, they're going to typically have two choices. They can sue in the defendant's home state where the defendant is subject to general jurisdiction, or I guess potentially some state where the defendant did something that affects all of the plaintiff's claims, like maybe where it designed the defective product. Or they can sue in federal court in a state where they were injured and then allow their claims to be aggregated in an MDL, where, as Andrew just explained, the new restrictions on personal jurisdiction after Bristol-Myers don't seem to apply or don't seem to have much traction. So given this choice, we think it's likely that many more plaintiffs are going to pick MDL. So most plaintiffs would prefer aggregation before a federal MDL judge chosen by the Judicial Panel on Multi-District Litigation to either suing alone in the state court of their choice or suing together on the defendant's home turf. So the result of Bristol-Myers is not going to be the scattering of these cases all over the country, but rather to drive even more cases into MDL. So if this is right, if Bristol-Myers is going to increase the federalization of mass tort litigation in MDLs, what does that mean for MDL? What should we think of this development? And so I'm going to offer 4 thoughts. So first, this might make settlement easier. Parallel state court litigation can often pose an obstacle to reaching a global settlement. Right? Different lawyers working on a different timeline in front of different judges can throw a wrench into things when you're trying to put together a global settlement. Having all or almost all of the players together in a single forum under the supervision of a single judge can really help set the stage for settlement. And this can be particularly advantageous if the defendant might be willing to pay a sort of peace premium to resolve all of the claims together. Second, this might be more efficient. So there are lots of advantages to concentrating similar cases in a single federal court. So avoiding duplicative proceedings is much more efficient for everyone involved. And while MDL judges and state court judges have shown, I think, a remarkable ability to work together to manage parallel proceedings, reducing that need to coordinate is going to result in savings and avoid the potential for friction when the judges butt heads. And I think there's also some intuitive appeal to handling nationwide disputes like mass torts in the courts of the nation, instead of risking inconsistent outcomes in 50 different state systems or allowing one outlier state to make decisions for the whole nation. Third, I think that increased federalization of mass tort litigation in MDL might result in some smoothing out in the differences of state law. And this ties back into some of the discussion that Sam was having with John in the last panel and the split personality that Andrew was talking about. So MDL formally respects the separate identity of each transferred case. And the MDL court is required to apply the same substantive tort law that the state in which the case was originally filed would apply. Right? The choice of law rules go with the case after transfer. Transfer into an MDL is not supposed to change the substantive rights of the litigants. So this means that the MDL court is going to be dealing with 50 different sets of state substantive law to apply to all of these claims. And I think part of the reason why MDL succeeds where the mass tort class action failed is that MDL is actually designed to handle this situation. So there is no predominance requirement in MDL like there is in the class action rules in Rule 23b3. So common issues don't have to predominate over all of the individual issues because formally at least, the MDL is just a temporary consolidation. It's not a representative litigation like a class action. But the irony here is that while MDL's formal adherence to these individual litigation norms allows aggregation where the class action could not, the very fact that these cases are aggregated, I think, may simultaneously undermine these norms, undermine the differences between these cases. So when a single federal judge has to apply 50 different sets of state law to a massive litigation, some smoothing out around the edges seems inevitable. And this is not to say that choice of law doesn't matter, right? Choice of law certainly matters.
I hope so.
When an MDL judge is deciding a summary judgment motion in a particular case or instructing the jury in a bellwether trial, it's going to decide that motion or instruct the jury according to the law that the transferor court would apply to that case. But there are plenty of opportunities for shortcuts and for grouping different states' approaches into broad categories in things like consolidated complaints or in deciding common issues on general causation. And as we heard in the last panel, when judges are deciding sometimes the most important motions in the cases, the Daubert motions, those are decided according to a federal standard, and that's going to apply to all of the cases. And the judges in the last panel told us that very often state law is not factoring into their consideration in those motions. And really, state law is not that different, right? You have a couple of different approaches, maybe 3 baskets of approaches that you can put together, and you'll figure it out. I can't fault judges or the lawyers handling these cases for trying to do that, right? This is a massive problem if you have to apply 50 different sets of law. And any ways to simplify, I think, are inevitable and not necessarily a bad thing. Probably the biggest opportunity for smoothing out differences in state law comes at the point of settlement. and John Wood alluded to this in the last panel too, where he says it's not the fact that these cases are in federal court that's smoothing out state law, it's the fact that all of these cases settle. So I think many of the people in this room know more about the content of MDL settlements than I do. Most MDL settlements are confidential. But at least in the publicly available mass settlements that emerge out of MDLs, they rarely make any sort of fine-grained distinction among plaintiffs based on the choice of law rules that would apply to their cases. So I've looked at the 12 publicly available non-class master settlement agreements and product liability MDLs. And out of those 12, none of them appear to take differences in the applicable state law into account in setting the recovery amounts. The recovery grids didn't factor in things like the plaintiff's state of residence or the place of injury or anything else that might go into a choice of law analysis. So what we end up here with is a system that formally accounts for differences in state law, but in practice smooths out some of those differences. And the more mass tort cases, like product liability cases, are channeled into federal MDLs and out of state courts, the more we're going to see developments in product liability law driven by federal judges. Federal judges who are faced with, I think, sort of an inevitable pressure towards simplification and uniformity that state court judges don't feel in these cases. And when all the action is in federal court, it's not quite, but it's starting to sound close to something like a federal common law, as Sam Zakharov pointed out almost a decade ago in relationship to Kaplan. Fourth and finally, channeling more cases into MDL is going to concentrate more power in the hands of MDL judges and the lawyers who control this litigation. Now, as I said, there are huge benefits to aggregating cases in a single forum, and empowering lead lawyers can help plaintiffs coordinate their efforts and prevent strategic holdouts, prevent state court lawyers from throwing a wrench into things. But there are also risks whenever power is consolidated. So in MDLs, individual plaintiffs often have very little control over their cases for as long as they're consolidated. And as Andrew said, there's no way for them to opt out. And the incentives of the lead lawyers, who are the ones who make the most important decisions, might not always line up perfectly with the interests of each individual plaintiff. And so we end up with a similar type of principal agent problem that we saw in class actions, but without many of the formal protections that are built into the class action rules. And one consequence of the Bristol-Myers decision in making it harder to file state court litigation is that it eliminates one potential competitive check by making it harder for competing lawyers to set up other aggregations in state courts. Now, as I said, there are advantages to that, but also I think some potential disadvantages. So with more power concentrated in the hands of MDL lead lawyers, I think it becomes even more important for federal judges, MDL judges, to manage the litigation with an eye towards protecting the individual plaintiffs, and importantly, making sure that they have the information that they need to make informed decisions about settlements and to monitor their lawyers. And with that.
Okay. Thank you, Teddy. I just wanted to translate something. You said smoothing out of state law. I think what you meant in English was running roughshod over state law. Is that right?
No, I think smoothing is what I mean.
Okay, I'll tell the translator then.
No, I think it's not disregard for state law, right?
It's general common law.
It's
not federal common law. It's general common law.
So I don't want to go that far. I don't want to say that federal judges are back in the Swift era where they're thinking, what is the right way to approach this problem, right? There's still the reference to state law. There's just pressure towards simplification. I think it was Judge Cannelli who said in the last panel, you can put it into like 3 baskets, right? That's not Swift. That's not general common law. It's just a practical problem that we're trying to find some way to get a handle And it's all going to settle anyway, and in the settlement, they're not going to account for it.
But it doesn't say you ignore it. I mean, in the class action context, they have figured out ways of subclassing and looking at these issues in groups, and there's no reason that that can't occur in this context as well, but it doesn't mean running roughshod over
What she
choice of
said.
law.
Adam, would you like to respond?
Sure, yeah, and just one thought, maybe it's not running roughshod, it's running smooth shot.
Smooth, I like it. I'll take it.
So it's been great to be a part of this conference. It's been really enjoyable so far. This is timely, interesting stuff. I thought the discussion this morning of testosterone and male energy was a good follow-up to Kanye's comments at the White House yesterday. But in terms of my designated duties here, responding, I don't have much to object to Robin's provocative comments, but I will just offer a few thoughts on some of those pre-BMS cases. And one thing I guess I'll say is, even though cases like McIntyre have left things in a bit of a muddle, I guess I want to emphasize it's not necessarily a more restrictive muddle or a muddle that has to be one that constricts the scope of personal jurisdiction. And here, of course, the saving grace is that Justice Kennedy's plurality opinion did not get 5 votes. And so as a result, if we're looking for any kind of law or guidance, and there's admittedly a lot of deep unresolved questions about how we deal with opinions that don't have or decisions that don't have a majority opinion, but if there's law anywhere, it's got to be in the Breyer-Alito concurrence, and that opinion is premised on a very narrow reading of the factual record in this case. And among other things, Breyer indicated that personal jurisdiction might have been fine if there had been, in the record, evidence of a market in the state of New Jersey, or evidence of New Jersey customers attending trade shows where the British defendant was promoting its products. That's consistent with a view that a defendant who benefits from a market in the forum state should be subject to personal jurisdiction when the product causes injury there, and that's the old line from Worldwide Volkswagen, that it's proper if the defendant delivers its products into the stream of commerce with the expectation that they'll be purchased by consumers in the forum state. A majority of justices endorsed that idea back in 1980, and we still don't have a majority of justices rejecting that idea today. Turning to the sort of general jurisdiction cases, the ones that enshrine this essentially at home test, I agree with Robin that they do work a significant doctrinal change in terms of where corporation can be subject to general jurisdiction. And it's interesting, of course, that some of the justices who might ordinarily favor greater access to judicial remedies have supported this change. It's been Justice Ginsburg, by and large, leading the charge on this new definition of general jurisdiction. And one reason for this, I think, might be the fundamental irrationality of general jurisdiction. I mean, to say there is general jurisdiction over a defendant is to say this lawsuit can proceed in this forum even if there is no reason on God's green earth why this forum should be hearing this case. And it's the same reason why transient or tag jurisdiction is controversial, because what difference should it make that the defendant happens to be served with process while they're physically present in the forum state? There's just no good reason. And I think one of the key questions going forward is, well, what if there is a good reason for a case to be proceeding in a particular forum? And I think that's what's underlying some of the questions that arise in the wake of the Bristol-Myers decision and some of the topics that Linda addressed. I think one of the doctrinal issues where litigants will battle this out, especially in the context of litigation, is where exactly this line is between specific jurisdiction and general jurisdiction. And what should we understand is driving the distinction between these two categories. And the test, to the extent we have one, is, well, there has to be an affiliation between the forum and the underlying controversy. And this, of course, would include cases where the lawsuit arises out of or relates to the defendant's contacts with the forum, but that's not necessarily the only kind of affiliation that can count. Bristol-Myers is, of course, the only Supreme Court decision to squarely address that question, but even it didn't provide a clarifying theory for what should be guiding courts going forward. One way we might tackle this issue, one way courts and litigants might tackle this issue, is to examine the practical reasons why a particular forum should be hearing a particular dispute. Not because that sort of functional analysis would override minimum contacts and all those basic requirements, but because they can inform whether the case has the required affiliation with the forum state to justify looking at the case through a specific jurisdiction lens. And I think that's what's oddly missing from the majority opinion in Bristol-Myers. It's, Alito writes in the majority opinion, of course, that it's not enough that California plaintiffs and non-California plaintiffs suffer the same injuries. But again, there was no consideration of the practical value of aggregating related claims arising from the same underlying conduct. Now, it may be that the actual litigation in Bristol-Myers didn't present a particularly strong case in terms of why you really needed multi-state aggregation. It didn't seem like these were low-value claims that might require broad multi-state aggregation to make them economically viable. But suppose multi-state aggregation was necessary to make even in-state plaintiffs' claims economically viable. That's a stronger interest that might create a more meaningful affiliation with the forum state. And maybe that's one way to think about some of the issues Andrew addressed regarding personal jurisdiction in the MDL court. It's the importance of being able to facilitate aggregation that creates the necessary affiliation with respect to the broader bolus of claims. And I think finally, this is one way we might conceptualize pendant personal jurisdiction, right? It's sort of part of that wider category of cases where a defendant has the basic level of minimum contact with the forum state, and there are practical dispute-related reasons for having the availability of judicial remedies against that defendant for that defendant's course of conduct be adjudicated in that forum. And we certainly let courts get away with a heck of a lot more than that in the context of subject matter jurisdiction, right? In the context of supplemental jurisdiction, we don't treat each plaintiff's claim as an independent unit that must independently qualify for subject matter jurisdiction. Article 3 of the Constitution permits all of the plaintiffs to come into federal court, potentially, even if some of those individual claims don't have an independent basis, as long as they arise from a common nucleus of operative fact. And, in a statute like the Multi-Forum, Multi-Party Trial Jurisdiction Act, you can even have a case where there's not even a semblance of subject matter jurisdiction. There's not even minimal diversity, but you can remove it to federal court because there's other litigation going on that's related for which there would be at least minimal diversity. So again, that similar logic potentially might apply in the personal jurisdiction context. And then I'll just close with one point about Robin's final observation about formalism. And that's just to clarify that, formalism doesn't necessarily have to be restrictive. I think Burnham's a great example of that. Right? Justice Scalia, noted formalist, says, let's just have a rule that says every time you get served with process, you're subject to jurisdiction. It's a very formalist interpretation, but it's a very broad interpretation. So one way to think about these problems going forward, if we assume that the powers that be are going to take a formalist approach, is whether there might be formalist approaches that are more expansive rather than more restrictive.
So I am going to choose not to take up more time responding, other than to respond to Andrew and Teddy about personal jurisdiction in the world of MDL. And Andrew in particular, I find attractive on one level the idea that maybe we should look at the transferee court. The difficulty I have there, though, is the basic assumption that the transfer should not effect any change of substance or change of a claim or defense. And personal jurisdiction is a defense. I mean, obviously, as the court said in Schutz, personal jurisdiction is not just about defendants, but it is typically raised as a defense. And if we start looking at the transferee court, then you really are transforming, in some sense, claims and defenses when you transfer from Court A to the MDL court. And I just wanted your brief response to that thought.
Yeah, that's not an unreasonable point. I mean, I think the way that I would think
That's the best I can hope for,
Yeah.
not unreasonable.
Not unreasonable.
Yeah.
It's different from reasonable.
Yeah.
I would say the way that I would think about this is to say, you've got to have personal jurisdiction under the usual rules in the transferor court. Then after the transfer, there should be personal jurisdiction in the transferee court, but measured by a different test. That is, measured by the test of whether or not it's reasonable under the Fifth Amendment. And what Adam says, I think, is the direction I'm going, is that there's a national interest in efficiently resolving nationwide disputes that's captured in the MDL statute. And that in most cases, sort of hearkening back to Mullane, which is something that Judith has written about recently, is this notion that as a practical matter, that interest is going to outweigh the individual inconveniences to the parties in these cases. And so if you look at MDL that way, a more sort of realistic assessment of what it's doing, I think it does pass constitutional muster, but not to deprive the defendant of a defense that there's no personal jurisdiction in the transferor court. So not only would it not deprive the defendant of that defense in the MDL court, it also ensures that if and when the case gets remanded, or if the case is going to be decided on a dispositive motion or tried as a bellwether trial in the MDL court, we know what choice of law rules are supposed to apply to that case.
Yeah, but Teddy is smoothing those over, if you recall.
Well, you do and you don't. I mean, I think the smoothing over is not running roughshod, because there are places where state choice of law matters. And it matters in these circumstances where the judge actually has to apply it. In individual cases, not instances where the judge is faced with the idea, oh my God, I've got to apply it 7,000 times. I'm applying it in this summary judgment motion, this bellwether trial.
So I think we have about a few minutes left for questions. Abby has a question.
Hi, Abby Gluck. I have a couple of comments and a question. So just in light of the testosterone comment, I feel compelled to say that the attorney who helped develop the at-home standard, my husband, is at home with the child right now. So I think that, we've made major progress here. So I can't resist that. I have a sort of a question comment for Teddy and for Andrew, actually. So with the smoothing out thing about the state interest, I think it's more than just state law, and this is a preview of tomorrow's 9 a.m. panel, so please wake up at 8:45 to come to our 9 a.m. panel. But thinking about when states bring cases, there's more than just state law at stake. There's state interest, there's the Attorney General obligation to stop a particular kind of harm in a state. So there's more than just the choice of law question, but the particular considerations that might be unique or different when a governmental actor in a state brings a case and they get bullied into the MDL. So I would just point that out and tantalize you all for the coffee that will be served tomorrow at 8:45.
In other words, it's not just private versus private in these cases.
Yeah, I just think that it's not just the amendment of the law, it's the whole stateliness and everything that could be going on. The other questions for you guys, I was surprised, I sort of thought that Robin, you were gonna go there. Surprised that in talking about where the personal jurisdiction cases are going, there isn't more talk of federalism per se versus nationalism, which is also sort of an implicit theme of what this panel has been about. McIntyre, that line, Kennedy's line, the sovereign by sovereign analysis versus Ginsburg, the argument that, the argument whether personal jurisdiction is really about 10th Amendment or is it about the Fifth Amendment, right? And so in thinking about the nationalism versus federalism debate, I think that's sort of an underlying theme. But the last question I had for all of you was, I thought, Andrew, you were going to go and start talking about plaintiffs' due process rights. And I heard it implicitly, but it wasn't the most explicit part of your remarks. And so isn't it possible that some of this MDL discussion is going to start flipping the considerations a little bit into getting us thinking not so much about the defendant's due process rights when it comes to jurisdiction, but possibly some of the plaintiff's due process rights, especially the ones that are being pulled across the nation or being pulled from state to federal court? Could that open up a different area of argument, constitutional argument for MDLs?
So Robin, then Andrew.
So, yeah, I agree. Sort of leaving the nationwide service of process question for later. It definitely put pressure on that, and just like we've seen more interest in the registration statutes, there's now, tons of articles and people advocating for various forms of nationwide service of process. Some people have been writing about it in the context of how it would happen only in federal courts. Other people have been making broader arguments, sort of the Ginsburg argument, that it is possible to think of New Jersey as just belonging to the United States. And I just want to throw in something not MDL related, but I think is important to point out, which is that I think there's a little bit of wanting to have cake and eating it too when it comes to subject matter jurisdiction and personal jurisdiction. And a good example is the Defend Trade Secrets Act that was passed a couple years ago, in which all of the interests who lined up in favor of Goodyear and Jay McIntyre for this really restrictive form of jurisdiction over foreign defendants came to Congress and said, we have a huge problem, everyone overseas is stealing our trade secrets, and the only way we can solve this problem is to have a federal forum for state trade secret law claims, but we're not going to add anything about personal jurisdiction to this statute, right? And it made no sense to me, and the only sense I could make out of it was that there was an urgency to sort of talk about the need to address conduct by foreign defendants, but really stopping short of enabling our courts to actually hear claims that would address them, right? So I think that there's now this game where we can sort of set things up where it looks like maybe we can hold foreign defendants accountable, but when actual litigation materializes, it's not really going to happen unless Congress gets serious about nationwide service process.
I'll say two things quickly. First, that I think the MDL statute really is an exercise in having your cake and eating it too, though I've never understood why you'd want to have cake if you weren't going to eat it. But putting that aside, I mean, the goal of the drafters of the MDL statute was to nationalize the power of the federal courts and to centralize that power. But by making the transfer only limited, it keeps that federalism patina available. It was very important to the plaintiffs' bar at the time the MDL statute was being drafted that the Van Dusen versus Barrett rule apply, because they did not want to lose the choice of law benefits that would attach to where they filed their cases. And so that was sort of a price of the plaintiffs' bar getting behind the MDL statute. So it's got both. It's got this nationalizing impulse while also trying to retain the rudiments of federalism there, and how that shakes out, I think, is a real question. I agree with you with respect to plaintiffs, and I'm more explicit about this in the paper, but I think that the issues for plaintiffs are actually perhaps even more important than issues for defendants. I mean, defendants in these cases, is it really inconvenient to deal with a nationwide MDL wherever it has to go? I'm not so sure about that. But if you're an individual plaintiff and you file your case and then it gets sent off someplace else where it might not have been brought, it's going to be prosecuted by a lawyer that you didn't pick, and it may eventually only come back to you in the form of a settlement offer. That seems to be a pretty major loss of control. And you're even worse off than an absentee in class action, right? The Schutz rationale of consent seems to me to be a pretty thin reed on which to base jurisdiction, and you don't have the right to opt out, and the judge isn't required to determine that your representation is adequate. And so if you're a plaintiff in an MDL, you may actually find yourself in a somewhat worse position.
Can I just throw in something here? I mean, all of these things that have happened with the MDL, I mean, it's not at all clear to me that at the time of the original MDL, anybody thought that all of these things were going to happen at the MDL. I mean, the language of the MDL is pre-trial, and one might think about things like dispositive versus non-dispositive motions being made in the MDL. I know that that's all sort of water under the bridge. It's all happened. But when you go back and talk about things like lexicon or things that the transferee court is not supposed to do, one at least pauses a moment to ask about the powers of the MDL, whether that's trying the case here in the MDL motion or sending it back or bellwether trials.
I think Judith has a question.
Yeah, I think this is probably the last question.
Okay.
Hi, Judith Resnick. So who wants to be in federal court? Why seems to be relevant to this. And in one era, I'm trying to remember the Starquist, what's the tuna fish?
Starkist.
Starkist, thank you.
Yeah,
So there's the
Alapata.
case where the
ExxonMobil.
defendants are trying to stay out of federal court and fighting, and then all of a sudden they say, gee, federal court's a good place to be, so let's change our view of how to read 28 U.S.C. 1332 diversity. And so here we are looking at who wants to be where, why, and we haven't much talked about the minimal diversity statute that is pending in Congress, with some people thinking it may well be enacted. And so we're looking now to the rush to federal courts. to aggregate to disaggregate because of the assumption that either through preemption of federal law of state claims or through interpretation or through mandated arbitration or through views of the negativity of aggregation, a new group of federal judges and some of the older some sitting federal judges who've been there for longer will come together to say, you can't proceed in these amalgams, invoking whether it's due process or federal, not attentive to federalism because the minimal due process, the minimal diversity statute is remarkably tone deaf to that, but rather looking at trying to reshape, to de-shape, to disaggregate and disenable adjudication. So it seems like that the doctrinal discussion has to get intersected with what's the periodicity, when's the doctrine being made, not just by what person, but with what gestalt about what imaginary, about what the federal and state courts are going to do. So it's a question for the various commentators about how that makes you think or how we should understand your comments in light of that.
Yeah, and I think that's something that we're going to have to wait and see how it shapes out. So in the Bristol-Myers case, it's very clear who wants to be in federal court. The defendant wants to be in federal court and is desperate to get to federal court. And after Bristol-Myers, it seems like plaintiffs...
Why?
Why? Because as Andrew said, they view the California state courts as the lowest common denominator. They're going to have unfair, plaintiff-friendly judges in California, and they want out at all costs. They wanted to be in the MDL in New Jersey, and the plaintiffs had structured the case to avoid removal under CAFA by breaking it up so it was groups of 99 and not 100, so it doesn't trigger the mass
But is the
action.
comparison between federal, or is the comparison, we know the judge in California state court and we know the MDL judge, we want to be before the MDL judge, or is it federal state? Is it Judge A, Judge B, or is it federal court, state court?
I believe, and Andrew, correct me if I'm wrong, I believe in Bristol-Myers it was federal court versus state court because they didn't know who the MDL judge was at that point. But that's also going to factor into the calculus, right? You might be quite content as a plaintiff to file in the defendant's home state in state court under general jurisdiction if you don't like the MDL judge. So it could affect the timing. I think one thing that's interesting about the federal court, state court choice here is before Bristol-Myers, it was very clear that defendants usually wanted to be in federal court, and one of the effects of CAFA, I mean, you could almost say that CAFA was designed to fail, right? It's designed to get these class actions into federal court, where if they're nationwide, they're going to face a predominance inquiry that if multiple states' laws are going to apply to them, they're going to have to do some fancy subclassing, or they're not going to be certified. MDL puts these cases into federal, or Bristol-Myers is channeling these cases into MDL, which is actually designed to handle them, right? And this goes back to the idea that it's a smoothing out of differences in state laws. It's not riding roughshod over state law. Choice of law rules matter and apply in MDL. It's just there's a pressure towards uniformity.
Okay, well, I know what article we're writing together today. We are plumb out of time. Please join me in thanking our panel.